Hearing in the appeal, the Queen against Luckhurst.
Mr Talbot.
Yes, may it please your Lordships. I appear together with Mr Hoyle, the appellant, in this appeal. The respondent is represented by my learned friends Mr Benjamin Douglas Jones, Queen's Counsel, Mr Rudolph, Queen's Counsel, and Mr William Douglas Jones. This is yet another appeal under the Proceeds of Crime Act 2002, and I use that expression advisedly. Your Lordships may recall that since 2000 there have been 32 appeals in this court or its immediate predecessor concerning the provisions of the Proceeds of Crime Act or its statutory predecessor, the Criminal Justice Act 1988. There is, as we understand it, another appeal under this Act, POCA, to be heard later this month as well. This case actually raises, as your Lordships well know, a narrow issue, and it's whether when the Crown Court makes a restraint order under Section 41 of the Proceeds of Crime Act to preserve assets for a confiscation order against a defendant in the event of his conviction, whether the court can make an exclusion to the restraint order to allow that defendant access to frozen funds in order to pay for the legal expenses of related civil proceedings. And so far as our oral submissions are concerned, we will confine those to 3 points, the first of which is the policy and the legislative purpose behind confiscation and compensation, because, as the court will know from pre-reading, the Crown Court is entitled and in some circumstances required to order compensation out of confiscation, and so confiscation operates as an umbrella for the recovery of losses to victims. So that is the first of the 3 submissions, which sets, in our submission, the context for the question. And the second of the 3 submissions is the language of Section 41.4 and the legal aid solution, which is a related topic. So the language of Section 41.4 and the legal aid solution. And the third of 3 points, which we will address in oral submissions, is assessing and weighing the practicality arguments, because the court will have seen that there are practicality arguments on both sides in relation to the competing constructions. The first of 3 points, the policy behind confiscation and compensation and its priority. Under this heading, we have 4 subpoints. The first is the primacy given to confiscation as part of the mechanism of dealing with convicted defendants. And we submit that that is clearly and conclusively illustrated by consideration of simply 2 sections in the Act. The first is Section 6 of the Act, which I can take the court to if it's needed, but none of these part of our submissions, I think, are controversial on the construction of the relevant provisions. But as the court will know, Section 6 lays down what is essentially a mandatory sentencing exercise in respect of convicted defendants. If the prosecution require it, or if the court considers it appropriate, the court must follow a series of statutory steps which are set out in Section 6, 7 and 8 of the Act. And at the end of those, must, subject to certain exceptions, must make a confiscation order in an amount equal to the lower of either the defendant's benefit from his criminality or his available amount, defined broadly to mean his capacity to pay the amount assessed as his benefit from crime.
Certainly, it would help me if you'd be kind enough to give us the electronic page references as you refer to sections. Or...
Yes, of course. It's EF 177 for Section 6.
Yeah.
It's worth observing in passing, because this impacts upon the third of the 3 overarching submissions, that Section 6.6 dissolves the duty of the court to make a confiscation order to a power if there is a victim of related civil proceedings. And we will come on to make submissions as to how that impacts upon the construction argument. But subject to that and one or two other exceptions, Section 6 lays down a mandatory procedure. If I can take the court then, and it may be useful to look at this section, it's Section 13, which makes, in our submission, the first of the four subpoints good and conclusive. Section 13 of POCA, which one finds at electronic page 191, and I think your lordships are all working from electronic bundles nowadays.
We are. I mean, we have a key documents bundle, but everything else is electronic. So if you give us electronic page numbers, that would be advantageous. Thank you.
My Lord, yes. 191 is Section 13 of the Act. And what this section demonstrates is the relationship between confiscation orders, compensation orders, and other potential financial penalties. And what it shows is, well, one can deal with it quicker by looking at the sections. Section 6, as I've indicated, lays down the mandatory procedure which must be followed first if there is an application for a confiscation order or the court considers it appropriate. And then under subsection 1, again, if the court makes a confiscation order, it must, so again mandatory, proceed as mentioned in subsections 2 to 4. The court must take account of the confiscation order before imposing a fine or making an order which falls within subsection 3, and just dropping down to 3A, that's defined to include any order involving payment by the defendant other than, amongst others, a priority order in subsection 3A, and in subsection 3A to section 13, dropping down below the, slightly below. In this section, priority order means any of the following, and there are the first of which is a compensation order. So what one has, looking at those sections so far, is a requirement for the court to take into account the confiscation order before considering any other financial penalty to be imposed upon the defendant. So plainly, if a confiscation order has wiped the defendant out or otherwise reduced his capacity to pay a fine or any other order involving a payment by him, then the court must take the confiscation order into account. But that's subject to an exception which includes a compensation order. So then if one moves on to subsection 4, subject to subsection 2, the court must leave the confiscation order out of account in deciding the appropriate sentence for the defendant. So when it comes to compensation, the court must proceed upon the legal fiction that a confiscation order has not been made, and therefore assess a compensation order on the basis that the defendant has not been the subject of a compensation order, on the basis that the defendant has not been subject to a confiscation order depleting his assets. And then subsection 5 cures the potential burden for the defendant by providing that if the Crown Court makes both a confiscation order and one or more priority orders, which is defined to include a compensation order, against the defendant in the proceedings, and the court believes he will not have sufficient means to satisfy all those orders in full, then subsection 6 applies. In such a case, the court must, again mandatory, direct that so much of the amount payable under the priority order, so the compensation order, as it specifies, is to be paid out of the sums recovered under the confiscation order, and the amount it specifies must be an amount that it believes will not be recoverable because of the insufficiency of the person's means. So what one sees in our submission from section 6 and section 13 is the priority of confiscation orders over fines, forfeiture, deprivation, all other methods of dealing with a convicted defendant financially, save compensation, and then the effect of section 13.5 and 13.6, or 4, 5 and 6, to prioritise the compensation of victims above confiscation but with the mechanism of confiscation being, as I put it earlier, the umbrella pursuant to which funds are recovered for the benefit of victims. As I submitted, it doesn't appear that any of these principles, or at least the effect of the statutory provisions which I've just set out, are in dispute. What we'd submit is the same as the expression used by Lord Roger, with whom Lord Stane and Lord Brown expressly agreed in the Seneje case. Again, the reference is Seneje. It's a 2005 decision of the House of Lords on the previous legislation, which had precisely the same statutory provisions, but the reference is EF 895, where Lord Roger described confiscation and so compensation having primacy over fines and other financial disposals.
Which paragraph?
It's paragraph 35.
35, thank you.
So our first submission is that the primacy point in relation to confiscation when sentencing a convicted defendant. And by confiscation, we include that. We include in that the compensation of victims under the procedure for the recovery of sums to be paid in satisfaction of confiscation orders. That's the first of the four subpoints. The second is the priority of confiscation and therefore compensation over unsecured creditors. This is conferred directly by Section 69 of the Act, as explained by the Court of Appeal in the Lexi Holdings case. It may be helpful to go to Section 69 because it is central to the point, and in fact has been referred to by the Court of Appeal and indeed this Court as the statutory steer which governs the exercise of the restraint order powers. One finds that at EF 333. And if your Lordships are there, your Lordships can see by reference to subsection 1 that the section applies to the powers conferred on a court by sections 41 to 59. We're concerned plainly directly with section 41, but the court may wish to note that section 58 is within that spread of sections. I'll come on to section 58 in a moment, but it's quite important that the court recognises that, and additionally the powers of receivers who may be appointed to manage assets or to realise assets to pay confiscation orders. Generally by subsection 2, which is subject to subsection 3, which is intended to protect innocent third parties. But subsection 2, the powers must, mandatory, be exercised with a view to the value for the time being of realisable property being made available by the property's realisation for satisfying any confiscation order that has been or may be made against the defendant. Paragraph B must be exercised in a case where a confiscation order has not been made with a view to securing that there is no diminution in the value of realisable property and must be exercised without taking account of any obligation of the defendant or the recipient of a tainted gift if the obligation conflicts with the object of satisfying any confiscation order that has been and may be made. Subsection 3 is there. I don't intend to read it unless anybody wants me to, but those are the sections which protect the value and protect the interests of third parties. Then one has, and again, perhaps I can take this quickly. I'll give the court the reference, Lexi Holdings, electronic page number 906, where the Court of Appeal authoritatively decided that the effect of those sections which I've just referred to is that unsecured creditors may not obtain the variation of a restraint order, and neither may a defendant obtain the variation of a restraint order to meet a unsecured debt, even if the third party is a judgment creditor. And the reference for the Court of Appeal deciding that is from paragraphs 80 to 88, where the final conclusion comes, Lord Justice Keane giving the judgment of the court.
Just give me the electronic page references, sorry. Paragraphs 80 to 88, but what's the electronic page?
Yes, 80 to 88, and paragraph 80 starts at 931.
Thank you.
That, we submit, is the direct route by which unsecured creditors are prioritised below the payment of confiscation and compensation. There's also a slightly nuanced indirect route in Part 9 of the Act, which deals with the relationship between insolvency processes and restraint orders. And again, I don't intend to take the court there unless the court wants to go there. There's no dispute on what the sections mean. It's section 417, subsection 2, found at page 389. And section 426, subsection 2, found at 393. And both of those sections have the same effect, the first in relation to bankruptcy and the second in relation to corporate liquidation. And the provisions of both those sections are that where a court has already made a restraint order and the defendant is either made bankrupt or a company a petition is presented for liquidation of a company, then the functions of the trustee in bankruptcy or the liquidator, as the case may be, cannot be exercised over assets which are subject to a restraint order. And we submit that it's worth reflecting for a moment on the effect of that. Plainly, it means that perfectly innocent creditors, even those with judgment, cannot enforce their judgments or recover their losses against restrained assets. Or to put it from the defendant's perspective, he is not in a position of being able to meet his ordinary debts as they fall due, nor clear them by the bankruptcy process until the confiscation and compensation procedures laid down in Section 6 have been completed. So a defendant may be made bankrupt, but there can be no vesting of his assets in the trustee in bankruptcy, or a company can be liquidated and they don't fall within the liquidation. There can't be any distribution plainly by the trustee in bankruptcy or the liquidator to any of the creditors of the defendant or corporate defendant, as the case may be. And we submit that this is a further principle interpretive provision which demonstrates overwhelmingly the parliamentary intention that property subject to restraint is earmarked for the fulfilment of the statutory purposes laid down by Section 6 and Section 13.
Yes, you'd be saying, I suspect, that because of this regime, the priority given to the restraint order and the eventual confiscation order, that if a defendant to a restraint order or to a confiscation claim is faced with civil litigation which might impact on the restrained assets, then the appropriate course would be to stay those civil proceedings pending the outcome of the confiscation.
Yes.
Is that your position?
That is one option, one option is available. We would say that the difficulty ought to be addressed at an earlier point in the context of these kind of cases, and that is that we don't get there. And we don't get there because the right construction of Section 41.4 is that it doesn't permit the Crown Court a discretion to release assets to meet the legal expenses of defendants who are embroiled in civil proceedings. And your Lordship's question, of course, that doesn't stop the civil proceedings proceeding simply because a defendant isn't represented by a lawyer.
Yes.
And so if one is in that kind of situation, there may be circumstances in which it would be in the public interest for the civil proceedings to advance before the criminal proceedings. And that may sound counterintuitive, but if one takes, for example, a situation of a real dispute in relation to ownership of property, and it may be some kind of proprietary claim, as all members of this court will be very familiar, and some extremely familiar claims, proprietary claims, and are a common feature of fraud cases. And it may be simpler and in the public interest for that kind of proprietary set of interests to be resolved in the civil proceedings, yes, rather than in the criminal proceedings. And that isn't contrary to Section 69 or the stay steer, which I'm coming to right now, because, as I indicated, Section 69(3) protects and gives priority to innocent third-party interests.
Yes. Yes.
So I'm sorry that's a slightly more complicated answer than your lordship might have envisaged.
My task was to obtain your answer. Thank you.
I hope I've provided it. But it does lead neatly to the third of 4 points, because presciently, my Lord Hodge anticipates the effect of Section 58 of POCA. Again, the electronic reference is page 310. And a few moments ago, I invited the court to note that the statutory steer in Section 69, which requires assets, paraphrasing, to be preserved for the payment of a confiscation order, applies to any court and included within its spread of sections, Section 58. So Section 69, imposing this obligation to preserve assets to pay confiscation orders, applies to Section 58. And what Section 58 at page 310 says, and we can go there if the court would wish to, it restricts the power of the civil courts to levy distress over goods which are subject to a restraint order, and restricts the power for the civil courts to order forfeiture of real property leaseholds. And then it's the stay point that my Lord Hodge put to me a moment ago. It also empowers the civil court to stay civil proceedings or allow them to continue on terms, and requires the prosecution to be given a right of audience in the civil court to address it on those issues. So that's Section 58. And the exercise of that inherent jurisdiction of the court to stay its own civil proceedings is subject to, as I've said, Section 69. So it's worth reflecting in our submission that where there is a dispute, for example, over property ownership, or there is a proprietary claim, and that's proceeding in the civil court, the civil court's general principles for continuing the claim or staying it are set aside and are replaced with the requirement under Section 69 to exercise the stay power in order to make sums available to meet a confiscation order. And just to complete the third of 4 points, we respectfully part company with the respondent, and this may be the only area in the statutory analysis where there is a difference, certainly in this part of our submissions. The respondent refers to the Snoras case, which, again, I don't intend to take your lordships to it, but it's found at page 489 in the authorities, which was a civil claim, pretty standard civil claim nowadays, perhaps unfortunately, but the pillage by bank officials in former Eastern Bloc country of funds held by the bank, and civil proceedings brought by the bank, which was subsequently in liquidation to recover the sums which had been misappropriated. Those were the basic facts of the civil claim. But Mr. Antonov, who was a former principal of the bank, was also being investigated by the Lithuanian authorities, who sought his extradition from the UK. And the Lithuanian authorities put the CPS into motion, who obtained a restraint order over Mr. Antonov's assets. And it's worth the court noting that the restraint order was obtained under a statutory instrument which replicates almost identically the same statutory provisions that we are concerned with in Part 2, and in particular Section 41 and Section 58. And for your Lordship's note, the article of the statutory instrument is Article 17 of the External Requests Order, the Proceeds of Crime Act 2002, External Requests and External Orders Order 2005. Your Lordships can find the full reference in the Snoras case, but Article 17 of the statutory instrument replicates Section 58. Forgive me for that rather long introduction to the case. The point is that Mr. Antonov, facing extradition and potential criminal proceedings in Lithuania, argued for a stay of the civil proceedings brought against him by the bank, but confined his arguments to the general ones that one often sees, pretty well trodden, that having to fight the civil proceedings in advance would expose his criminal defence and was unfair and in some way impinged upon the privilege against self-incrimination. And that argument was rejected by Mrs. Justice Gloucester, and she applied the well-known principles that, save in exceptional circumstances where you can show serious prejudice, that argument simply doesn't run generally in civil proceedings. And we accept that as a principle, and the respondent relies upon that. However, the point is that Section 58, or its equivalent in Article 17 of the External Requests Order, was not brought to the court's attention. Nobody from the CPS appears to have been invited to attend, and certainly made no submissions on the issue. And nobody, it seems, made any submissions, and certainly Mrs. Justice Gloucester does not refer at all to the effect of Article 17, the equivalent to Section 58, on the exercise of the stay powers. So in our submission, the Antonov case isn't of any assistance at all in what a civil court should do when faced with a POCA situation where Section 58 is engaged and the court is required to exercise its powers with a view to satisfying any confiscation order which might be made. So the fourth of 4 points was actually quite a short and simple point, and it's about the legal aid exception which was introduced into Section 41 of POCA by the 2013 Crime and Courts Act. And the simple point is going to be, and I only need to show the court the explanatory memorandum to make this point good, the simple point is that in circumstances where the legal aid agency has decided that a contribution ought to be due by the defendant to his legal aid, that contribution can only be enforced and payment may only be made to recover the contribution after the confiscation and compensation process is completed and the confiscation and or any compensation order has been paid. So even where the state is a creditor under the legal aid contribution scheme, the payment of confiscation and compensation is prioritised above the recovery of the state's debt. And I don't know if you want to look at the explanatory memorandum to make that point good, or whether it's more convenient if I just give you the reference. But the reference one finds in the policy notes the explanatory memorandum to the Criminal Legal Aid Contribution Orders Amendment Regulations, and one finds that from electronic page number 1127 1127. And one sees the point that I've just made in paragraph 7.5 and 7.7.
Seven 7.5, you say?
7.5 and 7.7, my lords, yes.
And that's 1128, I think, is that right?
That's at page 1128.
Okay.
So can you just explain to me how this then would normally work? You'd have a situation where, am I right in thinking legal aid has been provided, and then there's a question subsequently as to whether a contribution should be made, and you're saying that at that point it, in a sense, comes lower in the ranking, that is the right to for the state to get contribution, than the confiscation and compensation regime.
My lord, that's right. The amendment to the primary legislation inserted subsections into section 41, which permitted the court to make exceptions to allow contributions to be made by the defendant to his legal aid. However, the effect of the regulations which were made under section 47 of the Crime and Courts Act, which introduced these statutory provisions, makes specific provision to ensure that no payment may in fact be made by the defendant towards his legal aid from restrained funds until after the confiscation proceedings had concluded and any confiscation order had either been discharged or satisfied.
I suppose my essential point is this is after legal aid has been provided, though, as I understand it. So one will have had the case legally aided, and then one's talking about contribution afterwards.
Yes.
Yes.
Although, of course, my lord, here one is speaking simply of legal aid in the criminal proceedings. The only power to raise a legal aid contribution which was inserted into section 41 is in relation to the provision of criminal legal aid to defend the criminal proceedings.
Thank you.
The policy objective being, as is explained in the explanatory memorandum, that it was thought that there was public disquiet and it was in the public interest to stem the provision of public money to pay for a defendant's criminal defence in circumstances when he may have excess assets left over after the confiscation order is paid to meet those costs, those public costs.
Legal aid isn't available for companies, so if there is a company being sued, they can't have access to restrained funds at all, under your interpretation.
No.
Yeah. And is that compliant with Article 6?
It may or may not be, my lord.
And what happens if it's not?
If it's not compliant with Article 6, then the court, which is hearing the criminal proceedings, may have to fashion a remedy to ensure that it is compliant, and ultimately the court, if it can't fashion a remedy to ensure Article 6 compliance, would have to stay the proceedings.
And what fashion remedy are you suggesting?
Well, it would, in our submission, depend upon the complexity of the proceedings. It may depend upon the availability of pro bono representation. The whole issue was...
But it's not a statutory interpretation obligation under Section 3, is it?
Well, there may be a statutory interpretation obligation under Section 3 in relation to companies.
And what would that be?
I can see that.
And what would that be?
But that was one of the issues which arose in the AP and U case, and in the end that was decided by the Court of Appeal because a declaration of incompatibility was sought by the defendant in the case of the company, and the Court of Appeal took the view that there was nothing wrong in principle with the scheme, even though companies may not be able to secure legal representation under the criminal scheme for the reason that my Lord Stevens just observed, but the issue had to be determined at the point at which the criminal trial was underway, in the manner in which I've submitted for.
My understanding is that under Schedule 11 of POCA, legal aid was made available for restraint orders. It wasn't made available for anything else. I mean, is that correct or not?
Yes, yes. That's because in principle there's already provision for legal aid for natural defendants in criminal proceedings, but as my Lord observed, the same provision doesn't apply to companies. So, if we may bring together the 4 sub-points by way of a high-level summary of the purpose and policy of the Act, which in our submission then informs the language of Section 51(4), as it always does when one is interpreting a statute.
Well, was the purpose and policy of the Act to provide legal aid in circumstances where you couldn't get access to restrained funds?
Yes. Well, that is part of the purpose. May I deal with it in this way? May I deal with the purpose and policy to preserve assets first, and then tackle my Lord Stevens's question?
Yes, if you give your summary and then come back to the question. Thank you.
So far as the summary is concerned, other than the stay point in reliance on Snorris, which I've dealt with, the nature and effect of these provisions do not appear to be in dispute between the parties. The clear purpose, the first point is that the clear purpose of the legislation is the primacy for confiscation and compensation and preserving assets for those orders, even if that interferes with or otherwise affects the defendant's rights to pay his creditors, or indeed other courts independently to manage civil proceedings. That's the first of 2 points. And the second point is that the effect of Section 69 2C in particular is a statutory policy to preserve the maximum amount for confiscation and compensation following conviction for criminal offences as part of a sentencing exercise. Self-evidently, therefore, any reduction of restrained assets reduces the sum available for confiscation, and so the sum available to be paid to victims. It reduces the deterrent effect of what is intended to be, in our submission, a robust confiscation regime. And it's prima facie inconsistent with Section 69. So, obviously, we say that the meaning of Section 41(4) takes its colour from these policy objectives. And so Section 41(4) should be construed broadly to ensure the maximum amount of restrained funds is maintained. The second of our 3 overarching points, the language of Section 41(4) and the legal aid solution. Plainly, well, one should go to Section 41(4), which of course is found in first volume, page 251. The appeal plainly turns on the expression in paragraph A of subsection 4, where an exception to a restraint order is made under section 3. It must not make provision for any legal expenses which relate to an offence. It's those words that are the central words in contention, relate to an offence. And self-evidently, relate to is an expression of connection, and it's capable of a broad or a narrow interpretation, and that clearly depends upon the context of the expression in the Act and in the relevant sections in the Act with regard to its purpose. And I've dealt with purpose. But we would make the following 2 points, construction points, about section 41.4. The first is that section 41.4 A simply requires the expenses to relate to the offence, being the offence by reference to which the restraint order was made, tying in subsection 5. It doesn't provide that the preclusion is in relation to expenses which are incurred in proceedings for the offence, and it could easily have made that kind of provision and provided the self-contained definition for which the respondent contends, incurred in proceedings for the offence, including proceedings under this part, or the criminal investigation which led to the restraint order, would be, for example, a formula of words which would cater for the respondent's contention. Our point is that there is no tying in of the legal expenses to particular types of proceedings at all. And one can contrast that, the second of 2 points, one can contrast that with the way in which Parliament dealt with similar issues in other parts of the statute. The principal section which illustrates the point is found in Part 5 of the Act, so not in Part 2, but a different part of the Act. And your Lordships know that there is a process under Part 5 of POCA whereby the proceeds of crime can be recovered on a proprietary basis. So it's a part of the Act which is directed towards particular assets which are traceable to crime, can be recovered from those who hold it without prosecution or conviction, the so-called civil recovery process which is set out in Part 5. And self-evidently, the same issue arises as to preservation of assets pending the High Court making a recovery order if the conditions are satisfied. And the important point in our submission is to consider the only section which dealt with the release of funds which were subject to such a restraint, which was in force at the time the Act was originally enacted. It was subsequently amended, but the section which dealt with this at the time that POCA was enacted is section 252, subsection 4, which is found at electronic page 384. And we would invite the court to turn it up so the court can see the contrast in language adopted by Parliament. Page 384 is the original 252. Pausing there, just for a moment, so your Lordships can see the section in the context of the circumstances that it was dealing with. When POCA was first enacted, the only way in which a defendant could be prevented from dealing with the assets which were subject to a claim was by the appointment of an interim receiver, by interim receiving order, an order made by the High Court. There was no process of a simple freezing order or restraint order. It had to be an interim receiving order. So that was the only way in which a defendant's access to funds subject to an action could be impaired. And if your Lordships look at 242.1, there are provisions in relation to exclusions by subsection 3, reasonable living expenses, carrying on trade, business, profession or occupation may be made subject to conditions. And it's this, of course, subsection 4, that an exclusion may not mandatory be made for the purpose of enabling any person to meet any legal expenses in respect of proceedings under this part. So rather than use the expression in this subsection of any legal expenses which relate to the claim or something of that nature, Parliament specifically tied the restriction to the particular proceedings in question. And we submit that the use of different language is deliberate.
Can I just ask you about the fact that amendments have been made to this Act? As I understand your submission at the moment, it's telling us that we need to look at the Act as originally enacted, whereas I think it's probably common ground otherwise that we are construing this Act at the relevant time, which is presumably the time that this confiscation order was made. Is that right? In other words, including the subsequent amendments?
Yes, you're obviously construing the legislation now, as it applies now, to this Act. But because parts of this Act have been subject to amendment, Section 252(4) is an example of that. The issue and the way we would put the point of law is that generally amendments to a statute do not affect the meaning of that part of the statute which is not amended in the same way. And here one has Section 252 in relation to civil proceedings where the Act was amended, as my Lord Burrows is implying. Yes, of course, Section 252, subsection 4 was amended. It was amended by the 2005 Serious Organised Crime and Police Act, which changed the position so that a defendant could access his funds in order to meet his legal expenses. And they laid down a strict regime for the control of quantum in regulations. So that helps the court in our submission with a construction of Section 252, because, of course, later amendments assist to construe the mischief and the purpose of the amendment in relation to the provision that was amended, but they don't, in our submission, affect the construction of Section 41(4), because Section 41(4) hasn't been amended. Or to put it another way, the court, we would submit, can't reverse engineer a construction of Section 41(4) by reference to amendments which were made in 2005 to a different part of the Act dealing with a different regime.
Well, I understand that point. It might be said against you that our task is to construe the Act today in its full context, including all amendments.
Yes. I certainly, in principle, we wouldn't resile from that proposition, my Lord. What one can see from the amendments, and one can see that the Act has been continuously amended. I've already referred to two Acts which have amended it, the 2013 Crime and Courts Act and the 2005 Serious Organised Crime and Police Act. In fact, there are many pieces of subsequent legislation that have amended the Proceeds of Crime Act. It seems to be the subject of almost continuous amendment. The court knows that from 462 odd sections, which was its liberal spread to begin with. It's now over 600 sections. At one point, if one is looking at one particular part of the Act, which deals with the forfeiture of money in bank accounts, to find the relevant provision, one needs to go to section 303Z14, which gives an indication of the amendments. But the point is that, therefore, that Parliament has had numerous opportunities to amend section 41.4 to provide for the construction for which the respondent contends, to bring it in line, for example, with Part 5, where you can release funds to pay for your legal expenses, but has never taken it. So we submit that the principal source of the interpretive criteria is section 41.4 as it was first enacted, because on this issue it's the same as it was when first enacted. A different example of the same point that one finds in section 252.4 is in our submission, found in section 40, subsection 2, which is an example of the, which sets out the conditions which need to be satisfied before a restraint order can be made. It's page 249. And there one sees paragraph A of section 40, subsection 2. This is one of the conditions, satisfaction of which entitles the court to make a restraint order. The first condition is that a criminal investigation has been started in England and Wales with regard to an offence. So what one sees there is the tying by Parliament of a legal power into language which requires a criminal investigation to have been started with regard to an offence. So tying the power into the offending. So again, we submit it's an example of a linguistic technique open to Parliament in section 41.4 to connect legal expenses to those of a particular character by reference to the nature of the proceedings, which isn't, of course, what section 41.4 provides. Yes, for the court's reference, we do deal with this in our written submissions anyway, on the right approach to later amendments. The court may find a passage in the Brown case in this Court of Assistance. It's page 821 of the electronic bundle, and it's paragraph 24. If I can turn then to the second half of point 2, which is the legal aid solution. It's common ground that public funding is available for criminal proceedings and indeed for restraint proceedings, and one sees the statutory route for restraint proceedings, for example, in the Ries case where the statutory provisions were set out. I'm not going to take the court to it, but again, for the court's note, it's paragraph 42 at electronic page 446. Of course, and this touches on the question posed by my Lord Stevens. It can be seen that in criminal proceedings, without doubt, a defendant's rights include representation pursuant to Article 6. And the same might be said of restraint proceedings. Although it's right to say, of course, that in Re-S, the Court of Appeal categorised restraint proceedings as civil. So the Act, on one view, and on that view, went further than necessary in making express provision for restraint proceedings to be covered by a provision for legal aid. However, what we submit, and again, we don't perceive any difference in analysis of the statutory provisions. Different considerations arise, however, when considering the release of funds for related civil proceedings. The point is, of course, my lords, that there is no general right to legal representation if, for whatever reason, a civil litigant cannot afford to fund them, whether as a claimant or a defendant. Our Article 6 doesn't go so far as requiring equality of arms in a literal sense in this context, but only requires legal representation to be provided by the state if necessary, if a defendant cannot afford it, for whatever reason, including if his assets are frozen, in exceptional cases. And there's no suggestion that the common law has ever gone any further than Article 6. More particularly, of course, under Article 6, the right to representation, the exceptional circumstances, they arise under Article 6 if the litigant cannot represent himself effectively, or there would be obvious unfairness if he was unrepresented. And again, I'm not going to take the court to it, but the relevant authorities were considered in Re-S, and one sees them at paragraphs 54 to 55 in Re-S, electronic page number 448. If the court wishes to read a little bit more broadly on this, rather than put a lot of European Convention cases into the bundle, they're conveniently summarised. The court may think, as I say, this isn't a legal dispute on the analysis of the law in this area, but we've put the European Court Registry's guide to the state funding of civil proceedings to comply with Article 6 in the bundle, and you can find that it's only 4 or 5 pages from page 1118. But there's no dispute, we think, that the test for the provision of state funding where a litigant doesn't have the wherewithal to pay for a lawyer is whether he can represent himself effectively, or without representation there would be obvious unfairness, as I've just submitted. And what we submit is that the Access to Justice Act 1999, in force at the time, and now Section 10 of the Legal Aid Sentencing and Punishment of Offenders Act 2012, LASPO, is designed specifically to ensure compliance by the UK with its Article 6 responsibilities. And one can see that neatly illustrated in 4 or 5 paragraphs from the other S case, the decision of the Court of Appeal in S, Director of Legal Casework. It may be convenient to look at this because it's a quick way of reminding the court respectfully of Section 10 and how it's implemented. EF 842 is the S case. And one sees, I know the court will be broadly familiar with LASPO. Section 9 of the Act makes provision by reference to Part 1 of Schedule 1 to types of proceedings which in principle legal aid is available, called in scope colloquially, and all other types of proceedings are described as colloquially as out of scope, but Section 10 makes provision for legal aid to be available in out of scope cases. And in paragraph 4 of Lord Justice Law's judgment on page 846, one sees Section 10 recited.
Paragraph?
Paragraph 4.
4.
Page 846.
Thank you.
And there, at the beginning of paragraph 4, Lord Justice Laws describes the in-scope, out-of-scope expressions which are used, and then Section 10 for out-of-scope, civil legal services by subsection 1 are to be available to an individual if subsection 2 is satisfied, and the section is satisfied while the director, and that's the director of the legal aid agency, has made an exceptional case determination in relation to the individual and has determined that the individual qualifies in accordance with this part, and that's effectively a means and merits test. And then this is the point in subsection 3, for the purposes of subsection 2, an exceptional case determination is a determination that it is necessary to make the services available to the individual under this part, because failure to do so would be a breach of the individual's convention rights within the meaning of the Human Rights Act 1998. And then, of course, the remaining part of, well, it may be helpful to take the court lastly, and the only other paragraph of this judgment, paragraph 9 on page 848, which is an obvious statement derived from the Lord Chancellor's guidelines, Lord Chancellor's guidance, forgive me, paragraph 9, citing paragraph 8 of the guidelines. The purpose of section 10.3 of the Act is to enable compliance with ECHR and EU obligations in the context of a civil legal aid scheme that has refocused limited resources on the highest priority cases. And so whilst this case, the S case, was critical of the way in which the scheme was administered, in particular the complexity of the form required to make an application for exceptional case funding, the Court of Appeal found that the scheme was compliant with Article 6. Of course, even if it had found that the scheme wasn't compliant, it wouldn't affect our point. Our point is that Parliament intends, whether the administration is good or whether the administration is bad, that any case where Article 6 requires representation and the common law doesn't go further, that a defendant will be provided with state funding, public funding in any civil proceedings, if that is justified. As I've submitted, the main, or one of the particular criticisms which Lord Justice Laws accepted, in fact the Court of Appeal accepted in the S case, was the complexity of the application form. I'm not going to take the court to it, but you may want to note that we've put the current form into the bundle at page 1107. The court may later wish to turn it up. It's actually now a very simple form. There's only 5 operative pages, and the beginning of the form sets out the test for the caseworkers, which I've already identified to be the right one in law, whether the litigant can represent himself effectively or there would be obvious unfairness. So one would hope, or at least the Lord Chancellor's Department would hope, that the criticism advanced by the Court of Appeal of the administration of the scheme has now been remedied.
Short of a Human Rights Act point, might it be said that if we are trying to construe a provision which might be said to have either a wide meaning or a narrow meaning, we might take as important that an individual ought to be able to use money to provide for its own legal representation, even if that doesn't constitute a human right protected under the Human Rights Act. One might say, well, that's just an element of access to justice and general fairness. What would you say about that as a proposition?
2 points. The first point is that civil litigants have to choose whether to litigate and if so, make provision for their litigation and for lawyers if so so advised, even if they don't have any funds. The courts now are presented with unrepresented litigants on a regular basis. There's no principle of which we are aware which requires representation to be given, public representation to be given to litigants, or indeed any other type of representation to be given to litigants in the absence of an Article 6 breach. The only context in which the defendant's rights, well, that's not quite right, because my Lord Burrows puts a fair point to me. The main context in which the point arises is in the context of whether the litigant can fairly litigate his case. I accept the second point. I accept the broad proposition that any person should be entitled to access what is prima facie his own property in order to use it for such purposes as he pleases, including, for example, paying lawyers to litigate cases. As a broad proposition, I accept that. Of course I do. That's part of a citizen's fundamental rights, which exist to property without reference to the European Convention, which I think is the point that my Lord Burrows is putting to me. The issue is the extent to which the Act, with its purposes and policies, cuts that down in favour of prioritising the payment of confiscation and the compensation of victims. And we submit, for the reasons that we've set out, fully, orally and in writing, I hope, as part of the first of our 3 points, that the policy objective and the purpose of POCA in this regard is plain. It does intend to cut those rights right down to an irreducible minimum, we would submit. And the release of funds for related civil proceedings in advance of a criminal trial, which will traverse some, at least, of those issues, which is the test that we are propounding, is not one, we submit, which is prioritised above the payment by convicted defendants, when they are convicted, of confiscation and compensation to the victims of their crime. So what we submit about the legal aid system in summary is that Parliament, by LASPO and previously by the Access to Justice Act 1999, has always plugged the gap to ensure that there is compliance with such legal rights as do exist to state funding in civil litigation. And we therefore submit that it follows that the fact that public funding is not available generally in civil proceedings, but only in Article 6 breach cases, is no indication that the funding of such proceedings, the general run of civil proceedings in the absence of potential Article 6 breach, is permitted and not excluded by Section 41(4). If I can deal then with the last of 3 points, which is shorter than either of the first 2. assessing and weighing up practicality arguments. We acknowledge that there are practicality arguments both ways. First, considering the practicality arguments against us, we acknowledge that there are some cases where a Crown Court may be faced with a challenge to identify which side of the line a set of civil proceedings lie in order to decide whether funds may be released under Section 41(4) or may not. We submit, as your Lordships know, that if there is any overlap in relation to the facts or connected by the legal framework, where there is any such overlap, that Section 41(4) is engaged, and so the court has no discretion and cannot release funds to meet those legal expenses. And we would invite the court to note that, of course, any application, the context of this is going to be a restraint order that has been made and a defendant who seeks an exclusion. Applications for restraint orders, as one might imagine, in the same way as an application for a freezing order in conventional civil proceedings, are supported by a full witness statement, which must, amongst other things, comply with the duties of full and frank disclosure. Those witness statements set out the details of the matters which are under investigation or being prosecuted, as the case may be, because they have to show and meet the statutory test of a suspicion or a belief, as the case may be, that the defendant has benefited from his own crime. See Section 40, subsection 2, and Section 40, subsection 3 of POCA. So the facts of the criminal allegations are set out already when a defendant applies to make his application, if he does, for release of funds to fund related civil proceedings. Of course, similarly, if that's his application, then it will normally be the case, and the defendant will have access to the material anyway. It will normally be the case that the case has been pleaded, or would normally have to have been pleaded within 14 days of the civil claim proceeding being instituted, and often preceded by a pre-action protocol letter. And if there's been a freezing order in the civil proceedings, again, one sees a full witness statement. So our submission is, one can see that all the facts which are necessary for the conduct of the exercise for which we submit will be available to the court, and is certainly available to the litigant making the application for release of funds. And these, of course, involve a judge not trying alleged facts, but analysing facts and determining their probity in relation to the issue in question. We submit for what is essentially a factual test on the material in front of the judge, which we submit is a familiar exercise for any judicial office holder. And that's what the Crown Court has to do in our submission. We also submit, and our argument in respect of this is buttressed by Section 6, subsection 6, which I would invite the court to turn up. I mentioned it in passing in the course of my submissions. This is the provision, it's at page 178. This is the provision which dissolves the power of the court to make a confiscation order, or the duty of the court to make a confiscation order, dissolves it to a power if there is a victim of related civil proceedings. It is worth, in our submission, looking at subsection 6 on page 178, because one sees Parliament provided the court must treat the duty in subsection 5 as a power if it believes that any victim of the conduct has at any time started or intends to start proceedings against the defendant in respect of loss, injury or damage sustained in connection with the conduct. So plainly, we submit that provision requires an analysis by the Crown Court of the facts comprised in the offences and the nature of the civil claim to test for that connection between the loss and the damage sued for and the facts of the criminal offences. And that's essential.
Just going back to what the connection is, it's set out as in paragraph 16 of your case, first sentence.
The connection for which we contend?
Yes.
Yes.
Is that correct? That's your test. So founded on same or similar allegations means what?
That will mean that where the facts of the criminal allegations and the civil claim have as part of their factual substance the same issues of fact. And we contend for any overlap, my Lord. If there's any overlap, then there is a preclusion under Section 41(4). Otherwise, it would be impossible, we submit, or very difficult at least, or harder, for the Crown Court to conduct the exercise.
So the court could interpret your argument as being any connection is more than de minimis. Did you accept that characterisation?
Yes. Yes. Yes, my Lord. And what we submit by reference to Section 6.6 is that a similar exercise has to be conducted by the Crown Court. So Parliament envisaged that Crown Court judges can do and carry out this function. And of course, under Section 6.6, one of the important points, which leads on to the very last part of my submissions, one of the important points is that the function under Section 6.6 is one which the Crown Court judge will exercise and can only exercise at the time of dealing with the defendant after conviction for the offence. It's part of the confiscation process rather than the ancillary release of assets for restraint. And of course,
sorry, could you give me that point again?
Yes. The point is that the stage at which the court has to conduct the Section 6, subsection 6 exercise of deciding whether it has a duty to make a confiscation order or merely a power to make a confiscation order in a sum up to the maximum of the prescribed levels of benefit and ability to pay. When deciding that issue, the only circumstances in which that issue comes to be decided is when the judge is deciding on the confiscation order following conviction as part of the sentencing exercise. And that's relevant, we submit, because that is an exercise which can't be farmed out or farmed up to a High Court judge or be dealt with in another jurisdiction, even though it requires the Crown Court to analyse the facts and matters of the related civil proceedings. The point, therefore, we submit, is that Parliament intends and understands and specifically provides for Crown Court judges to be conducting the very type of exercise for which we submit. And
I was just trying to think through the practical effect of the test you're proposing, and taking as an example family proceedings in relation to children. If the allegations made by the child protection authorities are numerous against an individual, a restrained person, but just one of them is that he participated at some stage in drug dealing, that would be an overlap.
There are two answers to that. The first is that the overlap would be insignificant enough to come within the de minimis principle. And the second answer, which is slightly broader, is that generally the provision of public representation, public funding in family cases is generous when it comes to disputes over children. Family, as the Lords no doubt know, generally family proceedings are not those where public funding is available. That was one of the effects of LASPO compared with earlier legislation. But the position is different generally in relation to disputes relating to children. And one sees the list of types of disputes in Part 1 of Schedule 1 of LASPO, which identifies the types of proceedings where public funding is available. I accept, of course, my Lord Stephen's general point that it can be, there can certainly be cases where the effect of a narrow or marginal overlap is to deprive the court, on our construction of Section 41.4, is to deprive the court of any discretion at all. But what we submit, and we understand, of course, the consequences of that, but what we submit is that when one looks at that in accordance with the legislative purpose and the policy, and I've been through all the submissions, that one has to ask the question when interpreting Section 41.4 as to what Parliament actually intended, that's entirely unsurprising when one considers that what one's dealing with is a scheme for depriving convicted defendants of the benefits of their crime and complementarily compensating the victims of that crime. And the question is where should the money go, essentially? And we would submit that the priority, quite clear priority in our submission, is towards confiscation and compensation. There is, of course, and again we set it out in our written case, what might be described as a waterfall of waterfall process. For example, taking my Lord Stephen's example, there may be other funds which are not covered by the restraint order. There may be third parties who are willing to provide funding. Pro bono representation may be available. It may fall within Part 1 of Schedule 1 of the Act, as I've indicated, and so be in scope. It may be covered by the exceptional case funding process if the defendant cannot represent himself effectively, or there would be obvious injustice. So all those issues would necessarily be in play before one comes to the position that it might be regarded as unfair, that the defendant is entitled to access what is prima facie his funds to meet the costs of legal representation.
But why can't all those policies that you've been talking about feed in to a judge's discretion? I mean, nobody's suggesting that the judge has to allow particular legal expenses. So the sort of factors you've been talking about, you might argue against you, are the sort of factors that preeminently would justify a discretion rather than an absolute bar.
Yes, and of course we acknowledge that, and that in fact leads me neatly to the very last part of my my submissions, because it is possible to deal with the issue. It's possible to deal with the issue in an abstract sense by reference to a discretion. The question, of course, is not what is the best way of, from a blank sheet of paper, dealing with this issue, but what did Parliament intend in Section 41.4, looking at the purpose of the Act and construing Section 41.4 in context with all the interpretive techniques which are available to the court. And what we submit in relation to the discretion point is that it does run up against very difficult and, in many circumstances, insuperable practical obstacles. It gives the Crown Court judge pretty much an open-textured discretion, which is undefined, and as we submit, it creates a number of problems requiring the Crown Court judge to make all sorts of judgments, which we submit are pretty close to impossible. He has to weigh up, of course, the strength of the pull in Section 69, which by itself, of course, is workable. The statute provides for that. Section 69 always has to be in play when considering an application to the restraint order, because Section 69 says so. He has to consider not just the waterfall arguments, which I've just set out, but whether the defendant's position is adequately protected by represented co-defendants in the civil proceedings. There are then insuperable difficulties, the court might think, in relation to quantum, and one can very quickly imagine a set of rolling applications to release funds as the civil proceedings develop, and so the Crown Court judge continuously having to deal with this. And the problem, of course, is not just that the Crown Court judge is not case managing the proceedings, the civil proceedings, and not just that he is unlikely to possess the relevant experience and background to make those sort of judgments about quantum in civil cases. It's that he's also unlikely to have the assistance from the relevant parties to make those judgments. Plainly, the CPS who bring this appeal do not regularly conduct civil litigation, are not involved in the civil litigation itself. They not only lack the general experience to deal with this, but also the case-specific information that's necessary for the decision by the Crown Court. And yet further, whilst the opposing party to the civil litigation may have some material to assist the court, the opposing party is not and could not be made a party to the restraint proceedings for the purpose of assisting the court, and may not wish to. The solution to those problems, in part at least, suggested by the Court of Appeal, was that the civil judge who is case managing the civil proceedings could constitute himself as a judge of the Crown Court. We submit, however, that solution is partial, laborious, and unlikely to have been intended by Parliament, which of course is the key point. It's partial, as only particular judges have the power to sit as a judge of the Crown Court. We haven't put the statutory power for judges to sit in the bundle directly. It's Section 8 of the Senior Courts Act 1981, but it's cited in the Stanford case at paragraph 210, electronic reference 744, if the court wishes to be reminded of it. But the point is, it doesn't include masters, civil district judges, tribunals, and arbitrators. So it's only a partial solution. It may be, in principle, a solution available in some cases, but not all. Second of 3 points, it's laborious, because, of course, it requires, even before a decision is taken that the case ought to be remitted to or decided by a High Court judge, it requires an assessment by both the Crown Court judge and the appropriate authorities within the civil administration of civil justice for a High Court judge to sit to decide, and requires both judges to familiarise themselves with the essential facts to take the decision. So it's laborious and inefficient. But lastly, and most importantly, we would submit that it must have been unintended by Parliament. It cannot have been intended, we submit, to move the administration of restraint proceedings from the High Court to the Crown Court, which is one of the principal objectives of POCA. Only for it to hurtle back to the High Court on an application to vary a restraint order. We wouldn't say we're overstating the submission by putting it this way, that the idea that commercial court judges sitting in the High Court, for example, should be diverted to conduct cost budgeting in the Crown Court is unrealistic. Faintly absurd, we would submit.
Presumably, in relation to discretion, you have to form an assessment as to the likely chances of success, the judge, so that the person who's asking for the discretion to be exercised has got to set out all the grounds upon which they're proposing to defend or pursue the civil litigation.
Yes. That we would submit would also be a necessary requirement, or at least a fertile ground for debate. The position, we submit that the Court of Appeal were right to analyse confiscation and restraint in principle as lying between personal claims and proprietary claims in how, if the court has a discretion, how it should approach the issue. But the court will recall how the Court of Appeal in this case dealt with decisions to vary restraint orders for the purposes of living expenses and set out a whole series of criteria which are very close to those which apply in the case of proprietary injunctions in civil proceedings, proprietary claims and proprietary injunctions, as opposed to merely personal claims and freezing orders. And of course, as this court well knows, in proprietary injunction cases, one of the aspects which must be considered when deciding whether to release what may be the claimant's money to the defendant to defend the claim is prospects of success. Yeah, so we would submit that my Lord Stevens is right to say that is an aspect that would have to be considered if there was a discretion to release funds for these type of proceedings.
The restrained individual may say that in the civil proceedings all they want to do is not put forward a positive case, but just to put the other side to proof. And so there may be some difficulties there in trying to assess what the proof is of the opposing party when they haven't got access or haven't got the opposing party before you. So,
well, in the restraint proceedings, of course, the defendant who makes the application to vary a restraint order does have the benefit of legal representation because it's guaranteed by the statutory provisions. Yeah. But yes, and it would be a difficult exercise if there was a discretion, which of course is all part of the reasoning which we advance for the proposition that there isn't a discretion. So, my Lords, for those reasons, and of course those set out in our written case, we would invite you to allow this appeal. I don't know if I can assist any further.
Thank you very much. Mr. Douglas Jones.
My Lords, the Respondent's submission is that Section 41(4) does not preclude an exception to a restraint order to make provision for reasonable legal expenditure where the expenses relate to similar civil or family proceedings with a foundation on the same or similar allegations, alleged facts and or evidence as those of the underlying offence or offences. And in those circumstances, we respectfully invite the court to answer the certified question in the negative. As indicated in discussion between my learned friend and my Lord Burrows, what the Respondent is not suggesting is that because an application is made for legal expenses to fund aspects of advice, litigation or advocacy in civil proceedings, the hands of the Crown Court judge are tied so that a variation has to be allowed. We respectfully suggest that the correct interpretation of section 41(4) merely permits expenditure on legal expenses where there is an overlap in factual inquiry, and indeed where there is no overlap. It does not compel the release of funds, and by section 41(3) and 4, expenditure is only permissible if it is reasonable pursuant to the section 69 legislative steer. So we respectfully suggest there's no open textured landscape here, and if one pauses to reflect on my learned friend's first and third global submissions, that, we respectfully suggest, ignores the position of a defendant facing factually unconnected proceedings in a civil or family jurisdiction. My Lords, in terms of our approach, the structure of the respondent's written case is such that we respectfully suggest that approaching our oral submissions in that order would best assist the court. And with that in mind, there is overlap because of the nature of the various topics, and we can obviate the need for any duplication self-evidently. But if I begin, please, with C, which is at electronic page 107 of our submissions. And that's in the core volume at tab 7. We begin with the sections themselves. In other words, section 41 and section 40 and the interplay between the two. And self-evidently, we start with the wording of section 41(4) itself, where the words relate to an offence which falls within subsection 5 are included in paragraph A. Subsection, and of course that relates to both defendant and recipient of tainted gift. Section 41(5) specifies that the offence that is mentioned in section 42, or that is 40 subsection 2 or 40 subsection 3, if the first condition in relation to section 40 subsection 2 or second condition in relation to the second subsection is satisfied, and it falls within the subsection if the offence concerned, if the third, fourth or fifth condition is satisfied. In each case, the legal expenses must relate, therefore, to a defined criminal offence in relation to which a criminal investigation or criminal proceedings have been started. In each case where there are reasonable grounds to suspect or reasonable cause to believe that the suspect or defendant has benefited from his criminal conduct. The language of the statute, we suggest, limits the investigation or proceedings in relation to which there is a statutory bar on legal expenditure to those relating to an offence falling within section 41 subsection 5 and accordingly section 40 subsections 2, 3 and 4, which expressly refer to an offence and benefit from criminal conduct. My Lords, the offences precluded, the legal expenses precluded by subsection 4 are not defined as those which relate to conduct from which a defendant has benefited, even though that expression is used within Section 40 itself. And even though Section 41.5 refers the court back to Section 40 in order to define and limit how Section 41.4 applies and the extent of its reach. Thus, we respectfully suggest that wording which would have had the effect of the wording within the certified question was within the contemplation of the draftsman, but not used. But the other way of drafting the section, the subsection, in order to achieve the effect of the construction suggested by the appellant would have been to have used the language in the certified question itself or something akin to that, so that legal expenses were defined as being in respect of civil proceedings founded on the same or similar allegations, alleged facts and or evidence of the offences within the meaning of Section 41.5, which gave rise to the making of the restraint order. My Lords, with those submissions in mind, we turn to C2, which is Section 6 on page 108, again in the same tab of the core volume.
Just before you go there, I'm just going back to your paragraph 3 on electronic page 107,
yes,
which sets out the prima facie position that an exception may be made for reasonable legal expenses. And as I understand it, the point you were making was that the objections put by your opponent to a discretion and the complications that that might give rise to, working out prospects of success, etc., that all has to be done in any event in order to allow reasonable legal expenses in unconnected legal proceedings. Yeah.
Precisely.
Thank you.
And that, we respectfully suggest, is what the first and third global submissions of the appellant overlooked, because clearly in an unrelated, in a factually unrelated case, Section 41.4 has to apply uncontroversially so as to permit expenditure being drawn down from restrained funds. My Lord,
if I could, I'm sorry for interrupting, but I think you started by saying that Section 41.4 doesn't preclude expenses which relate to civil proceedings. And are restraint proceedings civil proceedings?
yes, they are.
Yeah. And does Section 41.4 restrain expenditure in relation to restraint proceedings?
Yes. Yeah. Yes. And it does so in headline form, and I'll come to this in due course in a little bit of detail, but in headline form, that is the position because the restraint proceedings are founded on the offence. And that's simply dealing with it in headline form, because I'll come back to that in the course in particular of the analysis in Ries.
But I do apologise, but subsection 4, the reason why it's excluded is because it relates to an offence.
Because it relates to?
Relates to an offence, which falls within subsection 5. They are, sorry, I'm just trying to understand the statutory language, because the test that's applied in subsection 4 is relating to an offence, and as I understand it, you accept that that would include restraint proceedings, which are civil proceedings.
Yes.
Yeah, because they relate to an offence.
Indeed. Forgive me. Yes. It mustn't make provision for legal expenses which relate to an offence. Yeah. That includes restraint proceedings, on the basis that restraint proceedings relate to an offence, dealing with it in headline form only at this stage, rather than civil proceedings unconnected with the criminal process, if I can put it in those broad terms, which do not relate to an offence. They relate to facts which relate to an offence, or facts which may be similar to the facts on which an offence is charged or investigated.
So any judicial review of, in bearing on the criminal proceedings, would be legal expenses relating to an offence?
Certainly most. If one could contemplate potentially certain species of judicial review which may not relate to the offence, but in the general run of cases that would be the case, as we've seen in U Limited in particular, where there was the judicial review of the decision by POCA not to consent to a bank facilitating transfers involving a bank and the three appellants in that case. And in those circumstances, the overarching point is this: we respectfully suggest that the consent relates to an offence and the charge and investigation relate to the same offence. And as was set out in U, the point was that whilst consent would obviate the possibility of criminal liability, it wouldn't remove the fact that the proceedings related to an offence because the consent related to the offence. Lord, I don't know if that answers that.
Very much indeed. Thank you.
Insofar as Section 6 is concerned, we suggest that Section 6.6 is important, and we suggest that it should be borne in mind that in the context of Part 2 of the Proceeds of Crime Act, Section 6 is an extremely important, if not the most important, section. It's set out for ease of reference at page 177. And it prescribes the staged way in which the Crown Court must approach the making of a confiscation order. And as my learned friend has invited the court to look at subsection 6, that is important because the duty in section 6.5 to make a confiscation order becomes a power if a victim starts or intends to start proceedings for loss, injury or damage in connection with the conduct. And so here, Parliament had to grapple, we respectfully suggest, with what wording to use, where there were concurrent civil proceedings arising out of the same factual or evidential inquiry as the criminal proceedings. And this is precisely what the appellant suggests that Parliament was doing in enacting Section 41(4). We respectfully suggest that if Parliament had wanted Section 41(4) to have the effect the appellant says it has, it would have caused Section 41(4) to have been drafted by reference to conduct constituting the offence, not the offence itself. And again, going back to the submission made in overarching terms when looking at the interplay between sections 41 and 40, it could have done so by using language akin to that in the certified question itself. My Lords, at C3, where you have our written submissions on page 109, precision of statutory language, the appellant suggests that the use of language related to criminal proceedings and related to Part 2 would give rise to the construction contended for by the Court of Appeal and indeed by the respondent. Our submission is that it would leave out of account criminal investigation. But in a sense, the appellant's submission in that regard is an artifice in terms of its being an argument, because if we're wrong in our submission that there'd be a lacuna in relation to investigation, it would simply be another way of saying the same thing. And in those circumstances, our submission about the construction by reference to the interplay of sections 41 and 40 would hold good, notwithstanding the appellant's contention vis-à-vis Part 2. My Lords, section D is construction contended for by the appellant, the first sub-heading being strained and unnatural gloss on the statute. And we respectfully suggest that the Court of Appeal Criminal Division was right to conclude that the appellant's suggested construction puts a strained and unnatural gloss on the language of the statute. As Lord Justice Popplewell said, giving the judgment of the court, section 41(4) does not talk of expenses incurred in proceedings which engage an overlapping factual inquiry with the offence. And perhaps I could invite you to look at the Court of Appeal decision, paragraphs 43 and 44, which are at page 144. And we respectfully suggest, looking at that first part of the ratio at paragraph 44, that the appellant's own language in the certified question tends to underscore that section 41(4) does not talk about expenses incurred in proceedings which engage facts or activity constituting an offence. In order for section 41(4) to mean proceedings which engage an overlapping factual inquiry, one would need the sort of qualification which has been underscored in the discussion between your lordships and my learned friend in connection with his contended construction. In other words, one would need to have in the rider about the more than de minimis characterisation of the overlap. Otherwise, my Lords, as he acknowledges, or tacitly acknowledges certainly, a very minor overlap in factual or evidential inquiry would cause there to be a bar on variation for legal expenses in proceedings unrelated to an offence, but obliquely related to the same conduct or facts or activity. And we respectfully suggest that one can't infer or impose on the statute that sort of qualification from the language Parliament has used. My Lords, turning to the next heading, if I may, which is RD2, which is towards the bottom of the page on 110. Purpose of statute frustrated. Again, we respectfully adopt the observation of the Court of Appeal that the suggested construction of the appellant would frustrate rather than fulfil the purpose of the statute. The court said that it wasn't difficult to envisage and multiply examples in which legal expenditure may be for the very purpose of preserving or increasing the assets which would be available in the event that a confiscation order were made. And we respectfully suggest that the case before your Lordships is precisely such a case where one has many competing interests in the civil proceedings, many competing motivating factors to settle proceedings on a particular basis, with a little bit of practical legal advice, limited in this case to £3,000 on the application. It might have been possible to have some steer from a professional about a way of apportioning liability or a way of preserving assets. And my learned friends invited the court to look at section 58, and of course there's nothing preventing the CPS from intervening in civil proceedings, and that would have the effect, if the appellant be right, that the CPS could fund its own representation in proceedings in a civil jurisdiction in circumstances where the respondent could not participate represented, even to the extent of seeking advice on settlement. My Lords, D3.
I think the counter-argument to the arguments you've just put forward under your D2 is that this is all a bit unlikely, is it not? The chances that the civil matters overlapping with a criminal claim would actually increase the assets if they were defended, I think was termed unworldly by your opponent. What do you say to that?
Well, my Lords, there are certain circumstances which one comes across, I respectfully suggest, in criminal fraud cases reasonably regularly, where you might have competing interests between criminal defendants in a civil jurisdiction. And one may be claimant, one may be defendant, and the outcome of the civil litigation may preserve assets on the part of one defendant, which then preserves them for the purposes of confiscation. And the same may apply in a case such as the instant case, where you have a number of competing interests between defendants using defendants with a small d and Part 20 claimants, where some of those feature in the criminal proceedings and some of them do not.
Could you give me an illustration then of a competing interest between criminals where the assets are going to be increased?
Well, my Lord, I can give the court a specific example.
A hypothetical one, or any example?
There's a case before Sir Charles Grey, as he was at that stage in, I believe, 2005, in which I appeared for one of the litigants, where two defendants in a criminal case were suing one another in a civil case, and Bampton sued Rust and secured monies in circumstances where in the criminal proceedings ultimately Rust was acquitted, in fact on appeal. Bampton was convicted, and the upshot of the civil proceedings was that Bampton had retained monies that were then used for the confiscation order that was made against him following conviction.
Why can't you appoint a receiver just to deal with that?
Well, my lord, the point about a receivership is we respectfully suggest that it may not apply in that sort of litigation, which is necessarily expensive, but in the ordinary course of events, a receiver is going to be an expensive additional layer, and a receiver is not a qualified lawyer usually, and a receiver would therefore have to instruct a lawyer to advise in relation to civil proceedings. You end up with two layers of cost, whereas if the litigant was able to instruct lawyers himself or herself, then it would obviate that additional layer of cost. And we respectfully suggest that receivership has been, over the years, inherently difficult because of the amount of money that it costs the prospectively preserved assets for the confiscation order. I was going to move to difficulties in practical application of the appellant's construction. We've dealt with this insofar as the de minimis characterization of proceedings is concerned. There is nothing to limit the extent of the prohibition on the appellant's suggested construction. And the point made by the appellant in relation to section 6.6 about a judge having to determine whether there is a power or a duty is not the same exercise we suggest at all, because in that case there is a bright line between whether a victim of conduct has started proceedings or intends to against the defendant in respect of a loss, injury or damage sustained in connection with the conduct. There is no room for the power to remain a duty where a victim intends to start proceedings against a defendant, and de minimis cannot feature at all at that stage of the exercise. If a duty becomes a power, the judge can exercise discretion at that stage in accordance with section 6.5 and 6.6 as to whether or not there is a confiscation order. But at that stage, the fact that a victim's suit against the defendant is de minimis could be taken into account, but only in the exercise of discretion. With the appellant's suggested construction of section 41.4, once there is any overlap, there must be a bar on the release of funds. And as I've submitted, the imposed concept of de minimis cannot feature, as the Court of Appeal Criminal Division recognised. We respectfully endorse that, because there's no such concept in the statute, and you can't simply impose that language into it. My Lords,
so, I mean, do you have a definition of relate to?
Yeah.
A definition?
Yes.
Well, my Lord, I respectfully suggest it's unnecessary to define it, because if something relates to an offence, it is not the same as something, it's not the same as legal expenditure relating to facts with a similar overlap as the facts relating to an offence. The definition of legal expenditure relating to an offence caused the court some pause for thought in relation to S, where it had to grapple with whether or not a restraint order, legal expenses for a restraint order, were legal expenses which related to an offence. Because even that seemed oblique on the facts of the case until one analysed it by reference to Mr Perry's analysis by reference to legal aid and by reference to the purpose of the statute, in particular focusing on recipients of tainted gifts. And so in those circumstances, the definition of relates to an offence could be widened because of statutory purpose and because a restraint order and legal expenses relating to a restraint order do relate to an offence. But here, one is, we respectfully suggest, dealing with something more removed. That's no definition, but it is removed because what one is doing is one is looking at legal expenses which relate to facts or evidence or issues with a similar compass to those in the criminal proceedings.
Well, I thought you had defined your test at an earlier stage, and it was unconnected to the criminal proceedings if it relates to facts which relate to an offence. And I must admit to personally having some difficulty with that, because if you have facts which relate to, if there are facts which relate to facts which relate to the offence, surely that is relation to an offence. That's point number one. And point number two is, doesn't a restraint order do exactly the same?
Well, my Lord, if I try to cause my language to be more precise, if you are dealing with legal expenses which relate to the facts of an offence, that is one step removed from legal expenses which relate to an offence. And insofar as legal expenses for a restraint order are concerned, a restraint order cannot exist without there being an offence, whether it be part of the investigation or whether it be part of the proceedings. And legal expenses relate to an offence in those circumstances for the reluctant conclusion drawn by the Court of Appeal in Ries, in particular because of the relationship with recipients of tainted gifts and the purpose of the statute. So it's permissible to look at it in that context, but one is one step removed, we respectfully suggest, in civil proceedings with an overlapping factual compass.
Sorry, is the test therefore facts relating to the facts of an offence? That's one stage removed and therefore not relating to the offence. Is that the test?
If that is the test for when, forgive me, may I address your Lordship in this way and then perhaps come back to the question to see if it can be answered straightforwardly. Section 41(4) provides that where an exception to a restraint order is made under subsection 3, it must not make provision for any legal expenses which relate to an offence. If one includes in that which relates to the facts of an offence, that may or may not relate to the offence, which is why it's not worded in that way. And so if legal expenses relate to the facts of an offence, they may relate to an offence, or they may relate to, for example, civil proceedings which have an overlapping factual compass. But one isn't dealing with the use of that phraseology.
Take an example of civil proceedings for fraud, criminal proceedings for fraud. Exactly.
Forgive me, I missed the...
Sorry, criminal proceedings for fraud, okay, and a restraint order.
Yes.
Civil proceedings for fraud, all dealing with the same facts. Does that relate to an offence?
No.
Why not?
Because we respectfully suggest that one has to look at it in the context of the statute itself, and the legal expenses in the civil proceedings do not relate to an offence. They relate to the issue which is particularised in the claim in the civil proceedings. There may be a factual overlap, but that is not the same as relating to an offence. And we respectfully suggest that your Lordship's postulation there could have been addressed through the use of language such as conduct, which would have encompassed it.
The reference to conduct in section 6.6 is in relation to criminal conduct, and criminal conduct is far wider than the offence. Section 6.6 isn't an exact analogue. So the test, in the example I've given you, the facts in the criminal proceedings and the facts in the civil proceedings are exactly the same.
Yes.
Okay? So the test can't be relate to the facts which relate to an offence. Good. I'm just trying to find what test you apply to section 4.4, and I do apologise for pressing the point, but what is the test that you suggest I should apply, or this court should apply?
In relation to section 41.4, we don't propose to add any gloss to the language there. And in those circumstances, the offence is the offence which is then particularised through section 42 or 3. It's the criminal offence which is the precursor to the making of the restraint order on one of the conditions specified through subsection 5 and through section 42 and section 43. And in those circumstances, legal expenses relating to identical facts in civil proceedings would not relate to the offence, but they would relate to facts with a similar. They would relate to a similar or identical compass of facts, but in separate proceedings unrelated to an offence.
Section 41, subsection 4 doesn't refer to proceedings.
Section 41, 4 refers to the prohibition on provision for legal expenses which relate to an offence which fall within subsection 5, and then subsection 5 refers to the offences listed in section 40, subsection 2 or 3, and the offences listed, and indeed if the third, fourth or fifth condition is satisfied, and if one follows that through, section 40, subsection 2 refers to an offence with regard to which a criminal investigation has started, and section 40, subsection 3 refers to an offence for which proceedings have been started in England and Wales, and then section 40 cross-refers to sections 19, section 40, subsection 4 cross-refers to sections 19 and 20. So in other words, there must be an offence for which the defendant has been convicted. And then insofar as subsections 5 and 6 of section 40 are concerned, that cross-refers with sections 21, 22 and 27 of the Act, where there would be an offence for which the defendant has been convicted and a confiscation order made. And then finally, insofar as section 44 is concerned, there is a further cross-reference to section 28, where there is an offence in respect of which proceedings have been started but are not concluded. So, my Lord, it's our submission that an offence is pursuant to paragraph A of subsection 4 of section 41. That takes one to subsection 5, which takes one to section 40, and the subsections there, which takes one to specific provisions of POCA, which show that in each case one is dealing with an investigation or proceedings or conviction for an offence. And so when one is talking about the prohibition on legal expenses which relate to an offence, it is that offence, that criminal offence, to impose that shorthand gloss on it for that purpose that one is talking about. And so I do respectfully suggest that when one comes back to the overlap between a civil allegation of fraud and a criminal allegation of fraud, one is not dealing with offence as a term of art in the context of the civil proceedings. So in those circumstances, the prohibition relates to the criminal offence and not the civil offence, which is why there is the interrelationship with the restraint order and that species of civil proceedings, but not with proceedings which might take place in the Chancery or Queen's Bench divisions. My Lord, it may be helpful with that discussion in mind to look at the Court of Appeal analysis at paragraph 41 and 42 on pages 143 and 144, which is where Lord Justice Popplewell, giving the judgment of the court, dealt with his analysis.
Sorry, which paragraphs?
Paragraph 41 and 42, my Lord.
Oh, right. Thank you. Yes, in line 3 of paragraph 41, sorry, I beg your pardon, line 6, sentence 3, Mr Douglas-Jones submits that they do not extend beyond the confiscation proceedings themselves. That can't have been your submission, surely. They must include the expenses incurred. They're not in relation to any expenses incurred in relation to defending the actual offence, or is the point that there would be legal aid for that? Why isn't it the defending the criminal proceedings themselves?
Well, my Lord, that's the prohibition.
Yeah, yes, I realise that. surely the prohibition would directly be dealing with the criminal proceedings themselves, the proceedings for the offence. Doesn't just kick in at the confiscation.
Of course, no, it certainly wasn't my... No, I think that appears... that takes my submission slightly out of context in that there was, of course, a concession in relation to the criminal proceedings.
Right.
Forgive me.
Yeah. Yes, thank you.
My Lords, I was proposing to move on to D4, which was case law. I wonder if that might be a convenient moment before I start embarking on S.
Yes, I think it probably would be, because we're running ahead of the allocated time. The court will rise now. Thank you.